This case has everything: second chances, addiction, and a final moment of reckoning. Brandon Intosky stood before the Michigan court for yet another probation violation, facing the same judge who once believed in his rehabilitation. What began as a plea for help quickly spiraled into a heated debate between mercy and justice. The question on everyone's mind: how many chances does one man get before the system says, enough is enough? Stay till the end, because this sentencing shocked everyone in the courtroom.
Court is also calling People of the State of Michigan versus Brandon James Osentowski, file number 23-6926 FH. Time and date for that matter scheduled for sentencing. Mr. Osentowski is present, represented by attorney Michael A. Morosky. People are represented by prosecuting attorney Timothy J. Rakowski. Mr. Morosky, relative to the new files 47, 48, and 49, have you received copies of the respective information? Have you and your client had the opportunity to review them? And you waive the readings as well?
Yes, Mr. Osentowski and I did review them, and at this time we do waive the reading thereof, Your Honor.
Very well. As to all files and the respective information, how does your client plead at this time?
Not guilty, Your Honor.
Not guilty plea will be entered on behalf of the defendant relative to all counts. Any objection to scheduling this matter for a pretrial conference on December 1st, which coincides with another file that we have scheduled for pretrial?
We would have no objection.
All right.
We have no objection, Your Honor.
All right. All right. We'll schedule pretrials for those three files on that date. We'll do it at, should we do it at 9? Or 11? Let's go 11. We'll go 11 a.m. Just each file to those files. Any comment relative to bond at this time, Mr. Morosky?
No, Your Honor.
Mr. Rakowski?
No, Your Honor.
Bond will continue previously set in the three files, and that will address those. We'll proceed on those files in December for pretrial. We'll go then to 23-6926H. Mr. Osentowski is before the court on probation violation that was found earlier. Mr. Nathan Licht has prepared an updated probation violation report dated October 22nd, 2025. Mr. Morosky, if you and your client had the opportunity to review that report.
Yes, Your Honor.
Are there any additions, deletions, corrections, or objections to the report?
Your Honor, just one correction, because the sentencing date was moved from the 9th to today. We asked that it be reflect 86 days credit for a total of 306.
Total of 306. Mr. Licht, is that accurate?
I would concur.
Okay. Mr. Rakowski, you concur as well?
Department of Corrections is satisfied we are.
Oh, thank you. All right. Mr. Osentowski, anything else relative to the report? Any objections to it? Additions, deletions, corrections, objections to the report, other than what your attorney has stated?
You can feel the defense attorney fighting an uphill battle here. He's not denying Brandon's repeated violations, he's asking the court for compassion, highlighting addiction as the root cause rather than pure defiance. But here's the problem: the judge has heard this before. Substance abuse often becomes a recurring defense in probation cases, and while it deserves empathy, it doesn't erase accountability. What would you do in the judge's place? Give him treatment again or enforce real consequences this time?
No, Your Honor. Thank you. Mr. Rakowski, any objection to the report?
No, Your Honor.
Thank you. All right. Mr. Morosky, anything you'd like to say on behalf of your client before the court imposes sentence?
Yes, Your Honor. Mr. Osentowski does have one prior verbal violation of his probation, and that revolved around the use of alcohol. This probation violation also includes, possibly the use of alcohol. Mr. Osentowski does suffer from a substance use disorder, and an alcohol use disorder. If you go through his record, most of his criminal allegations, charges, convictions involve alcohol, Your Honor. Mr. Osentowski was doing well for a period on probation, aside from the one violation. He was engaged in counseling. Now, he was working on his relationship with his daughter. Now, we have reviewed the recommendation. Now, we'd ask that the court allow Mr. Ostrowski to attend TRICAP or some type of program that helps him deal with the substance use disorder, and get mental health treatment. For those reasons, Your Honor, we'd ask that Mr. Ostrowski be sent to time served on these probation violations.
Thank you. Does your client wish to address the court, Mr. Ostrowski?
Not at this time, Your Honor. Thank you.
You're welcome. Mr. Rutkowski, anything we have for people?
Your Honor, I have a letter I wish to read from the victim of this case. Go ahead. Your Honor, I am writing to respectfully request this court impose the maximum sentence for the probation violation committed by Brandon Ostrowski. Despite numerous warnings and corrective services, his behavior has not improved. In fact, there are now similar new charges that are going on through the court system that Your Honor is aware of. Further, proving that this is an ongoing pattern, not just a one-time mistake. The defendant continues to act as if the rules don't apply to him. Despite Your Honor's direct warnings at his previous sentencing, quote, "I do not want to see you back in this courtroom again for this," unquote.
This moment changes everything. The victim's letter hits hard, not just emotionally, but legally. She's not only asking for protection, she's documenting a pattern of danger. Under Michigan law, a judge must consider public safety during sentencing, especially when children are involved. Her words about intoxication during parenting time make this case less about relapse and more about risk. And suddenly, the tone in the courtroom shifts, from sympathy to fear. The prosecution seizes that shift immediately.
He has returned unchanged in behavior, unwilling to respect the law. My greatest concern is safety. One of the most alarming aspects of this situation is that he is not only drinking, but he was highly intoxicated during his parenting time with our daughter. He's made a conscious decision to be under the influence while responsible for our child, a clear display of recklessness and disregard for the responsibility and her safety. My family and I will be at risk when he is released. His intoxication during parenting time proves that probation and supervision have not been enough to protect us. I firmly believe that allowing him back in our community under similar conditions would only lead to further violations and danger. Your Honor, I ask you to prioritize the safety of my family and the public, given the severity of his actions and the ongoing disregard to the law. I respectfully request that you impose the maximum sentence available at this point, and only firm consequences can protect those at risk. Thank you for your consideration. So, Your Honor, we ask you to take that into consideration. We also ask you to take into consideration the information in the pre-sentence report. The court is in the unique position of having to sit on the district court level and hearing the nature of what the conduct was in the probation violation, as you heard the testimony in the prelim, which is the assaulted conduct and the strangulation of the victim in that matter. He's on for the charge of aggravated stalking. During that time, Mr. Lick had in his report pointed out there's been other times where he had been consuming alcohol. In this case, he was consuming alcohol. He had possession of ammunition, which he shouldn't have had, and then he engaged in further conduct. For those reasons, we ask you to adopt the recommendations of Mr. Lick. We believe they are appropriate and warranted under the circumstances.
Any other response, Mr. Weiss?
Your Honor, we just had the court to acknowledge whether there's been one prior verbal reprimand on probation. Mr. Ostrowski will admit he does have an issue with substances and his mental health. And again, that's why we're asking that he go out TRICAP or some kind of program so he can engage and work on his mental health and his substance use disorder, Your Honor.
Thank you. Mr. Ostrowski comes before the court on probation for aggravated stalking. The original case, which brought him to the circuit court. And at the circuit court level, his original guideline range was 7 to 23 months. At that time, the court followed the initial recommendation, low end of the guidelines, and afforded the defendant the opportunity to seek help and treatment to better himself, to make the situation down the road better for him. That's the ultimate goal. Obviously, there's punishment, deterrence, but there's also an aspect of rehabilitation. And the whole idea of rehabilitation is to put someone in a better state than they were when they came into the courtroom. And that was the ultimate goal in part as well. And if I recall correctly, Mr. Osentoski had very zealous attorneys representing him in that matter, very zealous attorney today in this matter as well. And certainly, the court always believes in giving individuals who make mistakes the opportunity to better themselves. That is the ultimate goal. The probationary term was ordered in this case, and Mr. Rakowski is right. I had the opportunity to preside over the district court proceeding, one of the 3 files that we have now in circuit court, just arranged just a few moments ago. And I have to stress, though, despite the fact that I presided over the preliminary examination and I found probable cause to believe that a crime has been committed and probable cause to believe that Mr. Osentoski committed a crime, that's not proof beyond a reasonable doubt. Mr. Osentoski is presumed innocent unless proven guilty beyond a reasonable doubt by a jury of his peers. And so when it comes to convicted behavior, there's no additional convicted behavior, so to speak. There's no conviction. There are three separate files. And again, defendant is presumed innocent unless proven guilty. But the court can at least consider what had been heard at that level, consider the behaviors, etc. And what I find significant is there was a point in time where the defendant was to be, if I recall correctly, DOC officials, Department of Corrections officials, went to visit on or about May 3rd, and I believe a PBT was administered at .019, but according to the pre-sentence report or the probation violation report, the defendant had fled. And, you know, at the end of the day, if it's alcohol, if it's just alcohol, that's the behavior involved. Certainly, programs can be looked into. I think that's where Mr. Roski's coming from. But you have to look at the entire picture here. And when the court looks at the entire picture, considering substance use issues, the allegations are merely allegations. But when I look at all this, Mr. Osentoski was afforded a great opportunity. The ultimate goal, as I understand it, was, and the court saw this in the domestic side, on the domestic cases with his daughter, what if he part of his daughter's life? And that's admirable. That's the whole idea. And that's what the court was thinking of too, rather than imposing a prison sentence right out of the gate. When the court could have, it could have gone 23 months to 5 years originally on this case, but was convinced otherwise, and the ultimate goal was to get him in a better state. And it doesn't appear we're there. As a result, the court finds the defendant has unsuccessfully completed his probation. He's unsuccessfully discharged from probation, and he's committed to the Michigan Corrections Commission and placed in the commission's custody in the state prison of Southern Michigan to be incarcerated for a minimum term of 23 months to a maximum of 5 years, credit for 306 days already served. All monetary obligations, if they're still pending or still owing, still apply. Don't want to do this, but under the circumstances, we've given Mr. Osentoski an opportunity, and sadly, it wasn't grasped upon. So,
in the end, justice caught up. Brandon Intoski was sentenced to 23 months to 5 years in state prison, a decision the judge clearly struggled with. This wasn't just punishment, it was disappointment. The court had offered help, but rehabilitation failed. Cases like this remind us, addiction complicates justice, but it can't erase responsibility. What do you think? Did the judge make the right call, or was this a missed chance for reform?
That will be the sentence of this court. 23 months, 5 years, credit for 306 days already served. It's my duty to inform you have the right to seek leave to appeal. If you're financially able to provide counsel of your own choice, court will assign counsel for a public expense. Please initial the receipt and questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the court. 42 days. That'll be all.
Thank you, Your Honor.